Hello, I am David Schraga, the Secretary of the Beverly Hills Bar Association's Entertainment Law Section, and welcome to today's program titled Protecting Minors in the Influencer Economy, the Child Content Creator Rights Act, and a Coogan Law Update. Before starting our program, the Entertainment Law Section wanted to acknowledge the support of our sponsor, Lawyers Mutual Insurance Company. For 5 decades, Lawyers Mutual Insurance Company has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that LMIC is directed by a group of dedicated lawyers themselves. They offer special rates with competitive premiums for a wide range of areas of practice, including entertainment law. You can learn more about them at lawyersmutual.com. And now I am delighted to introduce today's program moderator, Libby Morehouse. Libby Morehouse is an associate in the Los Angeles office of Gordon Reese Scully Mansukhani LLP and a member of the employment practice. She represents clients in a variety of employment and pre-litigation claims for wrongful termination, discrimination, harassment, and retaliation, as well as FEHA claims. Libby graduated in the top of her class at LMU Loyola Law School and was a member of the St. Thomas More Honor Society. During her time in law school, Libby served as a senior production editor for the Loyola of Los Angeles Entertainment Law Review. Libby also published her note on the need for legislative protection of minor children in social media during her time at Loyola. Libby, the floor is yours.
Hi, everyone. David, thank you for the introduction. I'm excited for our panel today. We are joined by two amazing panelists, Uduak and Tyler Cho. Uduak is a fashion and entertainment lawyer, a former fashion model, and the founder of Fashion and Law, a boutique law firm serving clients from the fashion, music, film, and digital media industries. Widely regarded as a pioneer in U.S. fashion law, she launched the first fashion law seminars at San Francisco Fashion Week in 2005 and developed the first West Coast modeling law curriculum. She also created and taught the first fashion law course at California State University, Sacramento. Her work includes advising on intellectual property, music, and media licensing, talent agreements, modeling contracts, and brand sponsorships. She also handles cross-border deals, particularly between the US and Africa, with a focus on the Afro beats music industry. We are also joined by Tyler, who is the founder and CEO of Tyler Cho Law for Creators and Creator Arc, a legal and strategic advisory firm representing some of YouTube's biggest stars. Known as the creator's attorney, she also serves as a fractional CEO and business architect for digital talent building platform native media companies. She helps creators go from six-figure brand deals to 7- and 8-figure businesses through intellectual property protection, digital product strategy, and consumer brand developments. Her clients have launched ventures inspired by breakout creator-led brands like Feastables, Prime Hydration, Chamberlain Coffee, and Skims. Before launching her firm, Tyler spent nearly 2 decades as an entertainment attorney in Hollywood, holding senior roles at Disney, Skydance, BuzzFeed, and top firms including Loeb and Loeb and Hogan Lovells. She served as lead counsel on 18 feature films, including Saving Mr. Banks, Cinderella, and Gemini Man. A graduate of UC Berkeley, Tyler is based in Los Angeles and is on a mission to ensure creators don't just get brand deals, they build empires. Today's panel is to discuss recent developments in the Coogan law and additional laws to protect children in social media, and we are very excited to discuss. Uduak?
Thank you so much, Libby, for the introduction. Hi, everyone. Happy New Year. I hope your year has been off to a good start. And Libby, very, very impressive with your accomplishments. Congratulations. Keep it up. I know we have a lot of law students too that actively participate. So here's where I want to start the conversation. I think often when I'm approached, particularly within the industry from practitioners as well as law students or recent grads, they always want to know how to get into the industry, or if you are, how you can apply it. So for our purposes, I want to share my background and then sort of take it into what we're discussing today. So let's start with when I entered into the fashion industry at 14 years old. I entered the fashion industry, and although I was here in California, which has the Coogan law, there was no trust account and no court oversight. with respect to the fashion activities, fashion modeling activities I was engaged in. So what that meant in practical terms were no protected earnings whatsoever. Again, no court oversight, no clear consent framework, and no clarity around ownership. And I find it interesting that I was working in a regulated state, which we'll get more into in terms of child performer law in California, yet I was effectively unprotected. So it's interesting. I obtained a work permit. I signed with a modeling agency with a contract, and nevertheless, none of the modeling agencies I ever signed with spoke about even minorized trust accounts, among other things. That was just silent. And unfortunately, that actually continues till today. Unless you're negotiating the bigger deals, you will find that within the industry, you do have agencies that are missing that part that's important where minors are concerned. All right, so quick background on the modeling side of things. Let's move to the creator side. So I've always had two trajectories because I graduated from college with a degree in communications. And I've always felt that as a lawyer, I shouldn't be stuck with just only practicing law. And more importantly, the area of law I was going into necessarily requires me to understand the business of fashion and entertainment. So I wasn't going to just hang my communications degree. So I've always straddled the fence of being a lawyer as well as a journalist. At some point, I got frustrated in my capacity as a journalist because the stories that were being covered about Africa, as many of you know, were very stereotypical stories that were just so behind. And I felt that that was crucial as to my identity, no, number one, as a woman of African heritage, and secondly, also as a lawyer and how I show up with representing my clients. I wanted to change that narrative. Additionally, there were no stories at all about fashion law. So I wanted to also change that narrative. And here you go. I get into the creator economy. That's back in 2006. I start blogging first, and then from blogging, subsequently on the music side as well as the fashion side, evolves into vlogs and ultimately podcasts. And between that time, what happened, and we get to hear a little bit more. We get into some of the legal issues that we are dealing with the new laws that have been implemented. Within that time, I had to navigate platform and monetization shift. It used to be you were blogging all day, every day, and before you knew it, it became this whole business. And structured had to be a part of it. And as you continue to grow with millions of views, lots of followers, hundreds and thousands of followers, brands started to approach big brands. And not only big brands, a lot of that also translated into perks, international travels, national travels, and all kinds of access that one would not necessarily have had. So as a content creator, I had to navigate all that, build brand partnerships with these brands approaching, shifted into the sponsored content, whole dynamics, and ultimately evolved from posting content to truly running a business. And as you can see, I'm showing you a sample of some of the businesses I ran, one of which was a magazine, because the blog evolved into podcasting, vlogging, and a full-fledged magazine. And Lady Bill magazine featured some of the top celebrities, among others, both on a national and international level. So what did I observe back then? First things first, we were, as content creators, we're building careers before the law even knew what to do or what to call us. And what were the key observations I observed in parallel with my experience in the modeling industry? Number one, no standardized contracts. I had the legal experience, so I was creating these contracts from scratch for the most part. There was a lot of IP ownership confusion, brands trying to figure it out, trademarks, copyright, who owns what, control over the talent, what can you create, what are the scope, or among other things, what are the liabilities that one may or may not incur. Because again, I had the legal background, I was making sure I was protecting my businesses, but for the most part, most content creators were oblivious to it, and brands as well didn't really know how to treat content creators. There was also parents that were, switching on their cameras and essentially acting as managers with complete zero oversight. All day, every day, vlogging their kids, every moment of it, from when they're born to what they're eating, when they're sleeping, among other things. Really, really nuanced, private situations that were coming into that context. And what was interesting was I also observed just in the capacity of the modeling industry, same parallel in the creator economy. You had children that were generating revenue without any kind of guaranteed access to earnings. Parents were the ones getting those earnings. So, two industries, we transition to just comparing two industries, same legal issues across two economic systems. So from entering the industry, the fashion entertainment industry as a minor, and I would go on ultimately to be involved in music and film and fashion and arts, all combining over and over again, the intersection of all of those arts, to becoming a creator and later legal counsel. I've lived both sides of the system, and I've seen how the same legal system dynamics continue to persist. The minors will create the value, the adults control contracts and revenue, and there's no real protection. And if you want real protection, that really depends on statutory intervention, not necessarily the intent, especially of the adults involved. Enter Coogan and why Coogan exists. And I already told you that California had those measures already, but they weren't necessarily implemented or enforced, particularly certainly in the fashion industry. So what's the big deal about Coogan? A lot of you probably have heard about Jackie Coogan, who was the film industry's first child superstar and earned millions. He becomes an adult and discovers that his parents, specifically his mother and stepfather, had squandered all his earnings, leaving him broke. He sues, and ultimately the outcome is that the parents legally controlled his earnings. Certainly, it was very, very disruptive. If you go back and look at the history, etc., the legislator felt like we wanted to do something about it to protect child performers. So as a result, years later, California leads the way in enacting what we now know as the Coogan Law. So what's the underlying principle there? Absent a statute, minors have no guaranteed property interest in their labor. The Coogan Law or Coogan accounts are now required in several jurisdictions, not just California. So you have New York, Illinois, Louisiana, and New Mexico among the key jurisdictions that now require that. So let's get into what we are now talking about. First, we're going to look at what the Coogan Law is all about, and then we'll look at the different updates. California Family Code Section 6750 to 6753 for all my family lawyers who are on this call with us. So you should be aware of this as well. I know sometimes we think entertainment law doesn't necessarily intersect as much with family law, but it certainly does. So when a minor provides artistic or creative services, a portion of their gross earnings must be preserved in a block trust account, a Coogan account. And for all you lawyers watching this with the state bar updates that you probably all received with respect to how to handle client trust accounts, even if you've not delved in this area of the law, the concept should be familiar to you in terms of just making sure you have preserve a block trust account. So what are the key requirements? You're getting 15% of gross earnings that must be set aside. Entertainment lawyers, we're always negotiating, dealing with, is it net or is it gross? So 15% of gross earnings must be set aside. Funds are the child's property, not the parents'. And it applies regardless of the parental intent or the family agreement. So what Coogan has always regulated is money. We're not going to get into the details of your morality or your fame or working conditions with respect to your children. But what we are going to say, looking at it from the Coogan law perspective, is, look, there's got to be accountability for the money that child earns. So let's go into the update. What's happening with the Coogan law update? What's changed? And what has changed is not necessarily the statute's text overall, but how it's understood and applied. That's where you have Family Code Section 6752 come into play. Artistic and creative services are no longer limited to studios or traditional media. And gross earnings include digital monetization, such as your sponsored social media posts, which I was talking about. Most of you should be familiar with that. If you get on Instagram and you see maybe a celebrity or influencer, and they have a product that they're advertising, you'll see at the bottom of that hashtag, sponsored ad, etc., per FTC requirements. So sponsored social media posts, your brand deals, your platform-based revenue, ads, subscription, affiliate income. So it's now expanded where it's no longer limited to the studios or traditional media. So what does that mean in plain English? That means the medium does not control. The function is what controls. All right, let's transition and look at why the Coogan update that we have now has a little more teeth. Number one, statutory mandate. Its enforceable trust obligation remains the same. And secondly, it's not platform dependent. And there's no exemption if you're creating this content, putting it on YouTube, TikTok, Instagram. And the overall rule is digital does not equal informal and does not equal any sort of exemption that you get for purpose of the YouTube, TikTok, and Instagram. All right, let's transition to yet another statute we're looking at, or a recent law that's passed, and that's the Child Content Creator Rights Act, Senate Bill 764, which expands Coogan's protections. I think it's always important to look at what a statute does and what it doesn't to make sure there's clarity and no confusion. So what does this law do? It recognizes minors in monetized online content. And it also imposes trust, compensation, record keeping, and enforcement duties, even in informal influencer context. So if you're hey, I'm just doing this for fun and just putting it on YouTube, no big deal, this requirement still applies. It also reinforces, very important key here, that parents are fiduciaries. They're not owners of those earnings. And that's obviously very important for that child that's put in so much labor, if you will, and has nothing to show for it, like the Jackie Coogan case that we discussed. So what it does not do, it does not replace the Coogan trust requirements. You still have to comply with that. And it doesn't create identical enforcement mechanisms as well. And so essentially, it's expanding the definition of covered performers to include minors in paid online content contracts, and also extends overall the classic Coogan protections to digital labor. All right, so let's look at the next statute to talk about. That's AB 1880. That also expands Coogan protections, and this also clarifies how earnings must be calculated and allocated when you have a content that is family run and revenue that's pooled or indirect. It supports enforcement where digital income was previously obscured or mischaracterized. What both bills I've just discussed do not do is, again, they do not replace the Coogan law. Pay attention to those nuances, especially when you're reviewing or talking with your client or negotiating those deals or drafting it. They do not reduce trust account obligations, and they do not excuse compliance because income is new or platform based. So let's look at the visuals of side by side what all of this laws look like. Coogan, so issue who's covered, Coogan law, minor performing artistic or creative services, AB 1880. The minor as digital content creator under contract, SB 764, minors featured in monetized online content. Is contract required? Coogan law, absolutely. AB 1880, absolutely. Senate Bill 764, no. The core rule, Coogan law, 15% of your gross earnings in Coogan Trust account. AB 1880 has the same 15% rule that applies to digital earnings. And with respect to Senate Bill 764, your child must be compensated and earnings preserved. Who sets it up? That's always important. I talked about my own experience when I started. With respect to Coogan law, again, looking at the fashion modeling industry, for example, the employer is responsible for making sure that's set up. And if there's no employer, the parent will, set that up as well. So AB 1880, similar to Coogan law with respect to who must set up the trust account. And then the Senate Bill 764, parent or the adult content creator. And then what's Coogan law, what's new, the baseline financial protection we already talked about. AB 1880, with respect to that, it closes a digital loophole in Coogan. And then Senate Bill 764 imposes that record keeping and child enforcement rights. Does it replace Coogan? Across board, no, it doesn't replace Coogan. And on the Coogan law side, that's not applicable since we're talking about Coogan law. And then what it really governs, Coogan law, you're looking at where the money goes, AB 1880, the digital earnings and its relationship to Coogan earnings, and then Senate Bill 764, accountability when parents control revenue. So what are your key takeaways as practitioners or law students or recent, grads looking into this? Number one, if you're advising parents understand that advising parents is distinct from advising brands, two different things, right? So we properly allocate for that from your intake process all the way to run and keep the main thing, and the lines clean. Number two, that trust accounts are non-negotiable. We already know how much reverence we have to have for trust accounts. It's no different when we're talking about the Coogan account here. Also, digital monetization triggers real liability, and contracts must reflect both statutes. Let me get to the conclusion side of things, and then I will turn it over to my colleague who will get into a little more of the legal issues that may arise there. First things first, what would have changed for me as a minor if we had the enforcement on the Coogan side, right? I might be sitting pretty rich now with if the earnings were allocated or more information provided to me, certainly on the enforcement side of things. Also, secondly, with respect to the protections that matter most in practice, as I said, both actually matter. Obviously, you got to tailor it to the facts of your case and what's going on in terms of how you deal with the drafting or advisory role, but both protections matter. And then with respect to the gaps that the law must still arise, before I turn it over to Tyler, just a few things I just want to highlight on the litigation side of things. I know she's going to talk a lot on the deal making side, and we'll come back and talk both deal making and litigation. But the first things that jump at me is on a national level, we know that's huge controversy over parental rights. And this, to me, raises the question of, great, we want to protect children, but are we doing too much? Is the state, is the government encroaching on parental rights? And how do you balance that from a constitutional standpoint? Secondly, if you are dealing with LLCs, for example, a lot of these content creators, I know at some point I converted into an LLC, and I know a lot of content creators generally move forward with LLCs or trust and family entities as a whole. How do you deal with that, or navigate that for purposes of the rules that have been set up? Another final part that I will talk about is from a litigation standpoint, statute of limitations. What's the timing and scope of the child's right of action, right? So when, what's the cutoff time to file or not file? What are the discovery rules? Are we tolling, the statute during the minority age? When does the clock truly start running on a child's claim? So those are some issues that jump at me. And on that note, I'm going to turn it over to Tyler. She's going to address influencer flight issues, the state versus federal gap, brand deal risk, and why platforms are exempt, and finally conclude also with attribution uncertainty before we get to the Q&A. So over to you, Tyler.
Before we hand it over, I had a quick question in the chat that I was hoping you could address.
Sure.
We talked all about the need for the trust account. So someone is wondering if there's a specific type of trust account, or if a Roth IRA for a minor is sufficient to comply with the laws.
Oh, that's a very good question. Generally, you have the blog Coogan account, but I think you would most likely seek the advisory of also your financial advisors when working in tandem with that, when you start talking about the Roth IRA accounts. So I would say you should also have a financial advisor there. I did for a brief minute work at Merrill Lynch, but I'm not certified to necessarily give the full scope of that discussion without getting more into the facts of that particular situation, and pairing it up with financial counsel as well, working in tandem with them.
Thank you. Tyler, on to you.
Thank you so much, Udak. That was amazing. Quick kind of, how do I shift the slides? I'm so sorry. Am I able to do that from my end? Because am I able to just shift to the next slide? I don't know who's controlling it.
Sorry, Susan, just tell Susan we're to advance, and she'll advance it for you.
Oh, okay, perfect. Well, thank you so much for that. I mean, that covered a lot of the things, that I was going to cover, but I think I would love to get into sort of the deal making side. And because I represent some very big creators, family channels, as well as some management agencies who manage very, very big family channels, I think it would be good to kind of talk about how this is really playing out in real time and in real life. If we could go to the next slide, please, Susan. I'm so sorry to ask you to do it. So, I think so I worked in Hollywood for 20 years. So I worked with the Coogan law. We had to go to, as a studio, when I was at Disney and we were doing Saving Mr. Banks, when we had minors, we would have to go to the court, right, to petition and for them to approve the actor to work in the film. And so the onus was really on the employer here, who is the studio. And now, because we're talking about creators, the onus is on the parents, right, to be able to keep records and make sure that they're setting up the trust accounts for their children. Now, I will say that the biggest issue that we have is in terms of calculation, right? So, the Senate SB 764 states that you have to share, you have to figure out if a child appears in 30% of the video, then you have to set aside 65% of the revenue that's attributable to the child's likeness. Udak, I see you have your hand up. Did you want to say something?
Oh no, that's probably a mistake. My apologies.
Oh, okay. No, no worries, no worries. So, this is the biggest issue because as an attorney, when my clients come to me and say, well, how do I calculate 30%? Because if we have a 10-minute video and the child is in the background for, you know, 2 minutes, like how do we, is it, and this is the biggest headache that we have right now in trying to determine, well, what is the proper calculation? And so what I say to my clients is veer on the side of being more inclusive, right? Because we are seeing a lot of these creators who are on these family vlogging channels. We think they're fine. We think they're happy. And the second they turn 18, we're seeing these stories of creators turning around and suing their parents because what they're saying is, I didn't want to do that. I didn't want my life to be played out on Instagram or on YouTube or on TikTok, and I didn't have a say in that. So we're seeing a lot of these creators suing their parents. And so if you're going to be a parent who is in charge of a vlogging channel, make sure that you are setting up those trust accounts. Make sure you calculate, towards being more inclusive. Like if you're not sure, I would say, the kind of there, because there's no bright line rule, I would say if your child is in most of your videos and they are the star, let's say, and you can tell, right? If you have videos that don't perform as well because your kids aren't in it, then your child is the star of your channel. And that's what I hear more than anything else, right? Is that the videos with the children always perform better. The ones with the parents, maybe not as much. And so I would say if you want to be really compliant, put 65% of that revenue aside for your children in a trust for them. Susan, can we go to the next slide, please? Thank you. So this is, it was sort of broken down already. This is defining what the two laws are. I mean, I don't think we need to go through it again because Udak did such a good job kind of explaining the differences between the two and how they've been updated. If we can go to the next slide, please. Thank you. Now, the one thing I do want to highlight for the attorneys, because we're all California practitioners, is this is specific to California. And so is it overprotective? I don't think so, right? You hear the story of Udak as a child model and then of Jackie Coogan. I think, as a parent myself, I think having these laws really protects the children, the child actor, the child creator. But one of the questions I get a lot from my clients who are based in California or who are in other states who are looking to potentially move to California is, well, what if we leave California? Will that make us exempt from these rules? And I would say, potentially, right? Like if you don't live in California and the content isn't being made in California, maybe. But if you have brand deals with brands who are located in California, then maybe that brand deal, that kind of jurisdiction would, the locus would be in California. So I don't know that it's true. Like you hear about this as kind of almost like an urban myth. Are a lot of creators exiting California because they don't want to be bound by these laws? I will tell you, the reasons why creators are exiting California is not because of this, it's because of the taxes. Most of my clients who are big creators live in either Texas or Florida or Nevada because they have the best, income tax laws. That's the reason why they're typically in other states. I haven't heard a lot of creators saying, well, I'm trying to escape, these two laws, and that's why we're moving away from California. If we could go to the next slide, please. Thanks, Susan. So these are the controversies, right, that we're talking about here. We've talked about the attribution uncertainty. It's very hard to calculate. What does it mean if it's 30%? How do you calculate 30%? So I am advising my creator clients to over allocate and to be very meticulous. Is this happening in real life? Much less than I would like it to, because it's, if you're doing shorts, like I have clients who put out 5 shorts a day, being able to track that is very hard. Now, I will say, as long as these videos stay on the platforms, then the children could potentially, have a way to go back and check the records. If you don't want to be sued by your child one day and saying that you did not properly protect my assets, you broke your fiduciary duties to me, I would say be meticulous and be really over inclusive of the revenue and what they're entitled to then to be under allocating. Let's talk about brands, right? So the brands themselves, I'm hearing a lot of brands saying that they're sort of terrified of accidentally violating child labor laws. So under AB 1880, brands and agencies now have to verify, right, that they have a Coogan Trust account before paying a minor creator. That this is just like if it's just a minor creator, like outside the context of a family. So the friction that I'm seeing is that a lot of brands are now walking away from these sort of family styled UGC content because the compliance, right, of having to pay for a trust or verify that they have a trust for, let's say, a $500 gift to campaign isn't even worth the legal exposure for them. So I'm seeing the brands kind of backing away from family style vlogging channels in that way. The vlog definition, the law is really broad. It covers sort of any monetized online content. Like Udok said, this isn't just YouTube, it's also TikTok, it's Instagram, and it's even monetized lives. Now, I want to touch upon the fact that it's interesting that the onus is being put on the parents and sometimes even the brand, but not on the platforms, right? So none of the platforms are being held responsible. YouTube, TikTok, Instagram, YouTube takes 30 or 40% cut, right, from every video, but they're not being held responsible in helping make sure that whether these kids who have, they're part of family channels are actually being protected, whether or not the parents have trust. The way, in Hollywood, the studios are responsible for that. So I think there's a gap there that's very ripe for some new laws to be written. And I've been hearing talks that this is something that might come down the pipeline in the near future, is holding these platforms accountable because they're making billions of dollars a year off of a lot of young creators. And why are they not being held to a higher standard the way they do in Hollywood? And there is a gap between the states, right? There's probably a handful of states that are passing these types of laws protecting creators. But there's no, there are no federal laws protecting creators. I think there's some talk of this happening, in the Capitol, whether or not those laws will be made. I think there have been some attempts to, submitting these laws for consideration, but I haven't seen a lot of movement there yet as to whether or not that it will happen. But I think with time it will. I mean, you ask any 5-year-old what they would like to do, and I think their dream job these days is to be a YouTuber, right? It used to be, an astronaut or a doctor or a lawyer, but now it's to be a creator. And I represent big YouTubers. I'm currently selling one of my clients' YouTube channel for $100 million. I just got back from speaking in Dubai at the 1 billion follower summit, where all the private equity money is coming into the space because they want to buy creator channels. They want to buy IP libraries. All the streamers and studios want access to their content. And so I think we're going to see more and more movement on these laws, hopefully to protect more creators and more children. There's a current Senate bill being passed to protect the mental health of creators, right? And I think, I don't know how many of you in the audience are creators. I would say if you're not a YouTuber, to definitely think about it. If you're going to create generational wealth, like that is actually one of the biggest paths, is creating a YouTube channel. I put YouTube channels into trusts for my clients' children because it's worth more than real estate these days. Mr. Beast is worth $5 billion right now, which is bigger than some Fortune 500 companies. So this is, no longer just the creator economy. This is just the economy these days. So, I think our job as attorneys is to help creators monetize, right? But in addition, our job needs to help them. It needs to be helping them survive their own success to some degree. And these laws are controversial because they treat, the family business as just the business, stripping away sort of the domestic shield, right, that parents have been using to avoid labor regulations for a decade. So I'm glad, that these laws have been passed. I wish that they were happening in more states than just the ones we've listed. But I think there are a lot of parents making a lot of money off of their kids. You look at Jordan Matters, who is one of the biggest YouTubers on the platform. His daughter Silas, has just launched her own skincare brand, and that's probably going to make $10 million. And he started out as a photographer, and then he started featuring his kids in his channel, and his views just exploded into the billions because people do want to see videos with children in it. But I think we need to do the right thing and protect these children to make sure that they're not being exploited, and that you don't hear stories like what happened to Udak when she was a child model. So that's sort of my presentation. I mean, Udak did such a great job going through the laws. I mean, Libby, if we want to open it up, maybe we want to kind of circle back at Udak. I don't know if you have anything else to add, but we could also take questions from the audience if there are any questions too.
You you covered it very well, so we'll look forward to answering as many questions as we can get in.
I have a question off the jump. Tyler, you're talking about the brand side of the potential risks with these gifted campaigns under AB 1880. Is there any sort of requirement under the law as it stands now if it's purely a gifted item or experience or PR for a portion of that value if they're not actually receiving a check or direct deposit to save a portion of that value into a trust account?
Yeah. No, I mean, gifts is sort of this, this is how things are kind of slipping through the cracks, because gifts is, it's just, what parents are saying is, well, if it's, a food item, it's something that is benefits the entire family, right? Like how do we equate that into an amount? I think that's sort of the most difficult part of this, is how do we actually calculate how much something is worth. I have heard that most of the time the gifts are not being calculated in that way. Now, look, if you're getting a MacBook or, a treadmill or something that is substantial, I would tell my clients you should put that in the record and say, well, we received a MacBook that was worth $2,000. We all used it, but it's harder then for the parents to say, well, am I supposed to then go take 65% of the value of the laptop and put it into the account? I think that's a really hard detail to enforce.
Yeah, I'll chime in. That would be very hard, but I think for best practices, because my concern is that the way the law is written, when I think I put on the litigation hat, it could really create a lot of strife with parents and children down the line. So I think for parents, number one, you have to come to the table treating this as a business if in fact you are monetizing and doing the things that the statute calls for you to do instead of setting the trust accounts, monetizing content of your children. So first, I think from an advisory standpoint, have parents come to the table understanding that this is a business, number one. Number two, what that entails is you go back to that record keeping aspect of it, itemize everything. Just get into the habit of just doing that because then you keep a nice paper trail. And if there are issues, you can always back it up and say, hey, yes, it was a gift. Here's what it was. Here's the value. Here's what I did with it. While, we still catch up, the law still catches up. I mean, over 20 years later, we're now getting to the law aspect of it and still figuring out what it means. And I think a lot of those key nuances will have to be litigated. But in the meantime, just basic accounting and proper documentation would help a lot of parents and counsel advising parents as well.
Definitely always seems like the law is slow to catch up when technology moves so quickly these days. And we're seeing the same thing with AI now that the law is having to scramble to catch up.
Indeed.
But when we're talking about this record keeping, especially with SB 764 and the onus really being on the parents, if you could, wave a magic pen and amend the legislation, how would you recommend any oversight or enforcement other than strictly just taking your parents to court, which I'm sure could be a really difficult
That's
thing
not a good
for
idea.
a minor or a freshly 18-year-old to suddenly be suing their parents? Do you have any recommendations for what that would look like?
I think it would be hopefully if the parent is smart enough to get counsel right off the bat. I think it would be our roles as lawyers to then guide. And I mean, we already do it. At least I think a lot of my colleagues do it on the entertainment and fashion side, where you're saying even though family is involved, we're going to keep things very clean. The conflict of interest paperwork you've got to sign, among other things, in the engagement agreement. So I think if we follow those principles, we actually play a more substantial role in guiding the parents if they're willing to listen and to present it in a way where they don't think that you're thinking they're trying to exploit their children, because the statute presumes that right off the jump. The other thing that is of concern also, I understand the protection with respect to children, but as a content creator, the immense amount of work it takes to create content. And at some point, just farming it out, hiring independent contractors to handle all of that, I almost don't see the statute recognizing the role of parents and the amount of work and resources and investment that they put into that. It's sort of like, oh, you're doing this. And then, so if there's a way to balance that where we're not pitting the kids against the parents, and then we as counsel are coming in and making sure we sort of provide that guidance, I think that would really make a big difference.
Well, to jump off of that point, I mean, I think the example I gave with Jordan Matter and his daughter was, he really, when Silas turned 16, really invited her to be a co-owner in the business, right? To be a decision maker with him. And she was the one who kind of pushed her skincare line. She was the one who was in charge. So I think the more that we can empower our kids to feel like they have a say in this, the less likely we'll deal with that lawsuit at 18, because I think when you take away a child's say in their power, that's when we sort of get those lawsuits. I think when parents are inviting their kids to not be just free labor, like to be a partner in their business, that's when I'm seeing a lot of success for these family channels. A lot of these family channels end up having the kids, when they kind of turn 13, 14 and spinning off and having their own channel. I mean, Silas has her own channel. And I have a lot of clients, I have Jenny Hoyas, who was 17 when I met her. She's now 20. And so these kids are being guided by their parents, but sort of, with the thought that here, I'm going to support you until you can do this on your own. And I have seen it being a lot, that's a much more beautiful end conclusion than the kids who are being told, well, you have to make 3 videos a day even if you don't want to do it, or I'm going to take away your sports because you need to be making content. Like, that's when I'm hearing those stories of parents being sued.
And let me add just one final thing. I think as practitioners, we probably have context too, especially if you're not in the family law area and you're looking at the best interest of the child. We have context on the sports side. And I'm sure there are many people who played sports, right? You have that overactive parent that really wants the child to be involved in everything. And now that we have name, image, likeness deals, among other things, it can be really overreaching. So if parents also have the internal check, I know sometimes we don't get into the psychological part for parents. Your time may come further in the future. You might be a 30, 40-year-old that decides you want to still go into the NFL or whatever. But at this point, it's your child's reality. Understand and respect boundary lines, and don't try to fill a void, if you will, of whatever you never accomplished through that child. I think that goes a long way. Mutual respect, even though you're the parent, you still also should have a inclination to understand the importance of respecting your children as well. So I think that's helpful in addition to what Tyler has just said.
Definitely. I think in the law, we have a tendency to always see the worst case scenario or see these horror stories of, these parents taking advantage of their children for the content, for the views, for the money. But I was so right with Jordan Matters. There are so many other instances where they really are setting them up, and the law is now catching up to provide that framework of support to continue to encourage that. Uduak, you had also briefly mentioned independent contractors, which leads perfectly into a question that we have about the difference in the way that minors are treated in music and by the labels compared to film side under Coogan. And so someone's asking if you could speak to the designation of employee versus independent contractors when it comes to minors, and if a minor could potentially qualify as an independent contractor under the Borello test for purposes of Labor Code 2780.
That's an interesting question. Well, first things first, from a fashion standpoint, usually when you have the contracts, you will have, the labor code compliance, right? So there's the general contract, and then there's yet another contract that is a standard form from in compliance with the labor code. But whether minors can be independent contractors, I think theoretically you can say yes, but practically I don't see how that happens, because you have to look at that control test. Are the minors the one writing the script? Are they the ones directing how the camera is going to go? Are they the ones in charge of the work hours and the time off, among other things? So if you look at the standard test of what constitutes an independent contractor, I don't think that would fall in line. And so necessarily, I think that would fail with respect to minors being categorized that way. However, if you have, for example, I've been following iShowSpeed, who is a content creator, and what he's done across the US, then Asia, and now in Africa is just mind blowing. And the story goes that his mom was so resistant to him being a content creator, I think, when he was a minor. And now it's just over 48 million people while he live streams. Incredible. So if you look at that from that standpoint, mom wasn't involved, dad wasn't involved, although dad encouraged, but he is controlling every aspect of his production and streaming. So arguably, and he's signing the deals himself, from what I understand, negotiating those deals, even though he has representatives. So I think one could make a strong case in that very rare, exceptional situation that that minor, if he was a minor doing all those things, that he would qualify for an independent contractor status.
So let me add a little more to that. I actually know, Speed is with CA, and I share a lot of clients with CA. And uh, in terms of I know there's a question in the chat about contracts and minors creating content when they're underage, and how does, how do uh, they actually get permission to be on the platforms? How do they enter into brand deals? And they do have to have permission, right? Like they cannot be making content on these platforms without their parents giving permission. They certainly can't enter into representation agreements or brand deal agreements without their parents, verifying and also signing as a sort of co-signer to those deals. So I do want to flag that the platforms are being very careful, right? They've gone in a lot of trouble because they have underage creators that they're making money from. So now, they're being extra careful with bootstrapping and making sure that the parents have given permission. Because I've also heard of a lot of kids getting kicked off of these platforms because they lie about their birth year, so that they can be 18. Snapchat's been very strict about that. And so I think more and more, I mean, like platforms and brands are very careful about it, and the parents are involved. And I think, the example of Speed, I think Speed is of age now, but I think when he was starting out, he wasn't of age. And you look at Jimmy, right? Mr. Beast, he started his YouTube channel when he was 12 or 13. His mom actually didn't want him to do it. He had to make his videos in secret. She said he had to go to college, and he just was like, I hate college. I hate education. And he did all that in secret. I think the rules maybe back then, 10 years ago, were a little less strict, and he could make, content. I think the platforms weren't checking as closely as they are now. So I think now for these kids to be making content, they do need to get parent approval, and the platforms check. They make the parents sign. I think they have to send the parents, driver's license. So I think there's a lot more oversight now, making sure that the kids that the platforms are making money off of are actually of age or have permission from their parents.
Yeah, and let me chime in on that. Number one, you do need the work permit. I mentioned that when I was 14, I had to get a work permit. My situation was actually even unique because at 14, I was a junior in high school. It didn't stop needing a work permit. And then not only do you need that work permits side of things, always remember to not forget the basic contract laws that we operate on, right? As a matter of law, does a minor have a capacity to negotiate a contract? Right. And we know that if we don't have the parent involved, then it's void as a matter of law in general. Right. There might be exceptions to the rule. So don't forget, when in doubt, or if you don't have a colleague to really quickly reference and call right away, that when in doubt, default to those general contract principles that we're all aware of.
Of course, basic contract law always still applies. Similarly, a lot of people, post casually on social media for their whole life, some, for a period of time before they get monetized. So does the law touch on any requirement to save money after the fact if videos were or content was posted of the child as a minor that later gets monetized once they've reached the age of majority? Or have we not kind of looked retroactively?
I'll kick it off, and then Tyler, if you want to. Well, if they become an age of majority and then decide to monetize, turn on their YouTube monetization or any other thing.
Or yeah, become eligible after the fact. Yeah.
They're adults. So I would argue that that's then completely on them, because that would be a protective parent that's not monetizing that content. So I don't see where the issue would be. I guess it's not spelt out currently in the statute, and I think I just saw or saw something about case laws. The laws have just been enacted, so obviously we're going to need time to figure that out in terms of case laws. But I'm just thinking on the right of publicity side of things, name, image, likeness. I don't see how that analysis would apply. I mean, parents were not. The goal is to protect you almost from your parents exploiting you. They haven't. They switched up all monetization. You're now an adult. Go and be blessed and do whatever you want to do and make your own bank. So I don't really see the issue there. But you never know. There are always nuances, obviously. Over to you.
Well, I'm wondering if the question is more towards, is the child potentially saying, well, you should have turned on the monetization and why didn't you, right? Like, so look, by the way, there are people who don't know that they're supposed to turn on their monetization, right? Because when they hit, it used to be 4,000 subscribers, 10,000 watch hours. Like, you're supposed to turn on your monetization. I actually have clients who were really big and they said, oh, I didn't even turn it on right away because I didn't know I was monetized. So, are there those parents who are not very savvy who didn't turn it on? And is the child potentially saying, well, you lost me a certain amount of money because you didn't turn on the monetization? I wonder if that's the question. But yes, I agree with Udak. If the parents were veering on like not wanting to exploit them and making money off of them and letting the child decide when they turn 18 if they want to turn on monetization, I would say good on the parent, right? So I wonder what part of that argument they're trying to make. And then I know we're coming up on the last few minutes. At the very end, Susan, and if you could just kind of flash both of our end slides, because I know mine didn't come up. If people want to reach out and connect, that would be great for both of us.
Yeah, and that's such an interesting point about what you raised, Tyler, because it brings all the family law practitioners on the call into play, right? Because assuming I don't do family law, but my former business partner, who happens to be my sister, does family law, and that's her whole thing. So I'm a little savvy with a few aspects of it, and I'm thinking of divorce proceedings, for example. One parent wants best interest of the child, absolutely do not turn monetization on. The other parent says no, best interest of the child, turn it on. And which one prevails when the child becomes an adult and says, "Hey, you should have turned on monetization." So that should be very interesting. But yeah, interesting question that you raised. That we will see how family courts generally handle it in the future.
And I think I had an even different interpretation of that question, more so asking if they've been posting just casually or trying to build a business as a minor and haven't been eligible for monetization, say then they turn like 18 and they become eligible on TikTok or YouTube, and suddenly those videos from when they were a minor start make earning them money. If that I think that might have been where the question was coming from, if though that would start counting towards the monetization that needs to be protected. But I would assume the answer is the same, that they're then earning that money as an adult.
Well, I wonder if there's, then, I mean, are the parents going to say that they're, entitled to some percentage of that? I guess that would be the argument that people would be making. But for the child, if that's sort of their channel and now they're 18 and they're monetized, like they would be making that money. And Udak, I want to pick up the point that you just made about, two parents. Like, I have clients who have family channels where it's the dad who's in the video with the kids and the mom is not, and the mom actually doesn't want the kids to be, in the video, and the kids are almost too young. I have a client who's like, the kids are 7 and 9 and they just love, doing fun stuff with their dad, and the dad is just recording. He used to be a Hollywood producer. So that is also happening in real life, right? Where the families disagree as to whether or not the kids should be in the videos or not. And I think, seeing that play out in real life is interesting because how do the parents decide whether, because the kids can't really, like, they're caught in the middle, and they don't, they don't know if they should or should not. But I'm just seeing it play out. There's no answer here, but I'm seeing it play out in some family vlogging channels where maybe they start out and it's fun, but then it just becomes too much, or their kids are getting recognized and they don't like that type of, there's no privacy left for their families.
So I don't know about you. I can take one or two more questions. What about you, Tyler?
Yeah, I'm okay for a couple more minutes if we
Okay,
have any more
just a
questions.
few more questions before we wrap
Yeah.
it up.
Yeah, we talked about the fact that the platforms currently are escaping any sort of liability, unlike the studios in Hollywood under the traditional Coogan law. Um, how do you see moving forward, or how would you propose that liability should come into play? Should they ensure a trust is set up for the children before monetization happens? What does that liability look like to you?
That's a great question. What comes to mind is one could argue that platforms are already having to deal with a lot of compliance issues with respect to the age that
Mm,
a minor even gets on. Like, at least in California, the 13-year-old cutoff for you to even be able to use their platform and have consent. Not only that, how their images are used. We know there have been class action litigation against Meta or Facebook, among others, in the past, YouTube, among others. So one could argue that there are already guardrails that are sort of limiting, especially platforms as opposed to studios, etc. But I think what we'll just have to see how that plays out, because I think there's an argument that could be made that they're already doing a lot more than studios were doing, and so to add this arguably would be hard for them to regulate parents and could really get in the way also of them maybe encroaching on how parents should be raising their kids or the monetization aspect. It's very, very dicey. What do you think, Tyler?
I actually agree with you. I mean, I think these laws being so new and because we don't have case law yet, it's hard for us. It's just like AI, right? It's like a lot of people ask me like, how would this be dealt with AI? I mean, I spoke at the MIT AI Summit. They wanted me to talk about whether or not the LLM's training was fair use. And I said, well, we're just going to have to wait for the Supreme Court to decide, right? And so some of these like some of these questions that we have, great questions, we'll see play out in the next few years in court as more kids sue their parents, maybe as, could there be a class action, where the platforms are being held responsible? I don't know, right? So I think we'll get more answers in the next few years with these laws with AI, and we just have to as practitioners wait for the courts to decide.
I think one way we can help from a practitioner standpoint is let's be proactive. Let's sort of like the way ultimately the fashion industry had to do with models, skinny models and size, appropriate size and minors on the runway, etc. We can have industry certainly create those standards, but we can create those model standards of what it should look like, especially for our clients that have major influence. And then they can implement that as sort of like an industry custom and practice. So that's one way to look at it because we really don't want kids suing parents left and right, ultimately. And we shouldn't have to wait for that long also to figure out this when it's real time negotiating those deals and trying to do what we can for true monetization and a future of a child and at least have the parents also. Everybody just benefits in a good way. We love the deals. We don't like the fights, even though we know we ultimately have to help prevent the fights or fight if necessary.
I agree with that. I mean, I think I always teach my junior attorneys, what we do is maybe 10 or 20% the law, and the rest of it's human behavior. It's guiding our clients in the right way. I mean, that example I gave to you of the two parents, I told the parents point blank, you two have to talk and figure out what is the best for your family. Like, do not put your kids in the middle. Do not, make them choose because they're kids. They can't decide. So we have to sort of sometimes step in and be the therapist or the coach and help them think about, well, how could this play out in real life? Do you want your kids to sue you one day? Because they don't even think about that, right? They don't even realize that's a possibility. So it's our job to sort of tell them, look down the road for them and say, like, do you want this? And a lot of them say, no, I don't want my kids to sue me. Most parents want the best for their kids. So what a great conversation. Thank you so much, both.
Absolutely.
thank you both.
Mhm.
Yeah. Okay. Thank you.
So Libby will close it out, or is Susan
Yeah.
close it out?
All right, this concludes today's presentation. Thank you so much, Libby, Tyler, and Uduak, for a fantastic presentation. I hope everyone here has a lovely afternoon, and thank you to our audience. Bye-bye.
Thank you, everyone. Have a good one. Cheers.
Thank
Bye-bye.
you.
Thank you.
Bye-bye.